Okay, good afternoon, everyone. I hope you're all well and you're all prepared. Let us get started. The slides are on the screen. We are going to talk about admissibility, try to distinguish expert evidence from the run-of-the-mill evidence and opinion evidence when it comes to experts, how to differentiate between what is an evidence versus opinion evidence. And we're going to start with New South Wales experience. We already know New South Wales is in Australia. Who was going to do the first case? Please let yourself be known. We're going to talk about the opinion rule in the Uniform Evidence Law of New South Wales. Who was going to present on that?
Mwalimu. Hello.
Yes, Ibrahim, go ahead.
Mwalimu, you allocated me a case. This is the SRIF PTYLT plus Hosha. It's an expert report, evidence, admissibility. So I don't know whether this is the case you're talking about.
No, I was talking about the New South Wales, the uniform law on admissibility. Yes, but I think that case refers to it, but I thought I'd given someone specifically that Rule 76 on the opinion rule. I remember I'd given you that case of Dasrif, Ibrahim. I think someone else has that.
Yes,
so no one's going to, no one's going to admit that they've been given that case to do. Hello, is everyone there? Is anyone there? Okay, I had a feeling this would happen. Yes, Enrique?
I'll let Bosco go first because maybe what I'm trying to say will be overtaken.
Okay, Bosco, go ahead. Okay, no, we're just going methodically because I'd given everything in sequence. So I wanted us to start with the actual rule and then see how it has been applied in the cases. So I think I'd given someone this rule to go and have a look. Anyway.
So I just wanted to say.
Yes, go ahead.
Last week, I could not attend the class because I had electricity issue, but Ibrahim shared his case with me, and I think you're talking about the opinion rule, and from our research, it does touch on that. So I'm wondering if it involves our case. I don't know, because that expert opinion rule, that first the opinion rule like blanketly, and then going into like experts, and then how are the opinions of experts supposed to be taken? So I don't know if it's our case that involves what you're talking about.
Okay, the case is involved. What I wanted us to do first was to actually look at what the rule itself says, and then the cases will show how those rules have been interpreted by the courts in New South Wales. But in any event, let us just proceed so we don't waste time. So I've got the slide up there. On the admissibility under the Uniform Evidence Law, that's Rule 76 which is the opinion rule. And according to this rule, opinion evidence is inadmissible. And the only exception to this rule on opinion evidence being inadmissible is where an opinion is based on specialized knowledge. I think someone's mic is still on. Could you please mute? Because it's causing a little bit of background noise. There's someone's mic that is on. Thank you. It's off now. Right. So the general rule is that opinion evidence is inadmissible, except where that opinion is based on specialized knowledge. And it says in Rule 76(1) that if a person has specialized knowledge based on the person's training, study, or experience, the opinion rule does not apply to evidence of a person that is wholly, let me start that again. If a person has specialized knowledge based on the person's training, note that, study, note that, or experience, those three issues, the opinion rule does not apply, i.e. the inadmissibility of opinion evidence, to the evidence of an opinion, to evidence of an opinion of a person that is wholly or substantially based on that knowledge. And that knowledge has to be based on training, study, or experience. Okay, so you can ask, a carpenter can give an opinion based on his knowledge, based on his training of carpentry or experience of carpentry. So an opinion that he gives based on that, on the study or training or experience of carpentry will be allowed. It will be admissible. But the general rule is opinion evidence is not admissible in court. And that's the only exception, where it is based on training, study, and experience. Are we together up until there? Are there any questions? Any questions? Right, so silence means everyone is good. So now, Ibrahim, go ahead with Dasrif.
Thank you, Malim. I would like to first invite my sister, Erika. We did this case with her together to introduce, then we'll also finalize on the admissibility, on the application of this rule.
Sure, that is fine. Go ahead, Erika.
Thank you. So how we've divided the case is that I'm just going to introduce the facts and the law, and then Ibrahim is going to deal with how the law was applied and what was the decision of the case of the court finally. So in this case, Mr. I don't know how to pronounce his first name, so I will be using his second name. Mr. Nawaf was a worker in the Dasrif, who is the appellant in the case. He worked for them as a laborer and then as a stonesman from 1999 to 2005. And then from 2002, he worked, 1999 to 2002, and then he worked independently in Lebanon. All this time he was exposed to silica, which is a fine dust which can cause diseases, respiratory issues. And so in between 2004 and 2006, he was diagnosed with diseases, including silicosis. And then he sued Dasrif for breach of statutory duty, negligence, and breach of contract. He alleged that it is them breaching the statutory duty, them being negligent, and them breaching their contract that made him get these diseases, but specifically silicosis, and specifically exposing him to silica dust. And so in his evidence, he called a number of witnesses, and one of them was Dr. Badson. Dr. Badson was an expert. He was an expert because he was a senior lecturer in the School of Chemical Engineering. He was also a chemical engineer at the University of New South, a lecturer at the University of New South Wales, teaching chemical engineering. So he was an expert in the field, and Naswaf relied on his evidence, his expert evidence, to show that in fact the exposure by this company had led to him getting the silicosis. And so the court applied the Evidence Act in the admissibility of the doctor's evidence. And so the most important sections of the Evidence Act 1995 of New South Wales was section 76(1), which we have discussed, the opinion rule, and section 79. So the opinion rule is basically that evidence of an opinion is not admissible to prove the existence of a fact upon the existence of which the opinion is expressed. So a person cannot come to give evidence of an opinion but evidence has to be evidence which goes to prove a fact. But one of the exceptions to the rules exists in section 79(1), which is if a person has specialized knowledge based on the person's training, study, or experience, the opinion rule does not apply to evidence of an opinion of that person that is wholly or substantially based on that knowledge. So an expert opinion, but not an expert just giving opinion in any capacity, but giving an opinion that is wholly or substantially based on their expertise, will be exempted from the opinion rule. And so in the construction of this opinion rule, I'll just go into it because it's this section 79(1) that is most important in the admissibility of this evidence. It's one, the assumption identification rule, which these rules that I'm mentioning exist in common law, which is that expert evidence is inadmissible unless the facts on which the opinion is based are stated by the expert by way of proof, if the expert can admissibly prove them, otherwise as assumptions to be proved. And then secondly, it's that an expert opinion is not admissible unless evidence has been or will be admitted, whether from the expert or from some other source, which is capable of supporting findings of fact which are sufficiently similar to the factual assumptions on which the opinion was stated to be based to render the opinion of value. Basically, it means that it's not just that an expert will come and then will say what they want to say and say that this is an expert opinion, unless the evidence has been or will be admitted to go and prove that these factual assumptions actually exist. And then lastly is the statement of reasoning rule, which is basically it's not enough that an expert witness evidence merely states the qualifications of the expert and the conclusion. So to avoid the risk of the trier of fact accepting the opinion without careful evaluations, the steps that the expert took to reach the conclusion and the reasoning must be stated in the evidence. How the expert used the expertise to reach the conclusion also has to be stated. Admissibility does not depend on the reasoning being correct. So it does not necessarily mean that the reasoning of the expert has to be correct in the way they state it. It just has to be stated there, because whether or not the reasoning is correct will come at the end of the trial when the judge is now considering all the evidence that is before them. But in order for this expert opinion to be admissible in the first place, the reasoning that the expert used has to be put in the evidence when they are tendering it. So I will let now Ibrahim give us how these laws were applied to the evidence of the doctor to see if it was admitted as evidence or not.
Thank you, Arike. As Arike mentioned, Dr. Basten, professionally, it's stated he's a chartered chemist. He's also a professional engineer and a retired academic. So the question was the opinion he expressed with respect to on the numerical and the quantitative level to the respirable silica was based on his specialized knowledge and training, study, and experience. So what decided was this: in order for Dr. Basten to proffer or to provide evidence or admissible evidence about the quantitative level of exposure, then it is stated that it is necessary for the party that is tendering the evidence to demonstrate that Dr. Basten specialized knowledge on his trainings, study, and experience that permitted him to measure, to estimate the amount of silica. So first is his training. Did it allow him to do the measurement itself first? So that was first need to be expounded. And then it's also indicated that in undertaking that field, for the party tendering the evidence to demonstrate that the opinion that Dr. Basten has expressed was wholly and substantially based on his knowledge. Yeah, so basically that you cannot just express an opinion that's not linked to the knowledge and experience. So in this case, it stated that it was felt that Dr. Bastian's training, study, and experience did not permit him to do the estimation. And based on his experience, it could be called ballpark estimate. That is just an estimation. So when there was during the period of cross examination, Dr. Bastian
Ibrahim, we've lost you.
He did not measure. Oh. He has never done any measurement. He has never done any measurement. So basically, there you see the machine that the plaintiff was only seen once, and then when he was asked whether he has done any measurement before, he said he has never done any measurement before. So for this reason, the majority considered that if Dr. opinion about the amount of dust that the Hausha was exposed to, then this opinion was not wholly based on his specialized knowledge, because it's something that he has never measured before. Now they are given an opinion. If you have never measured before, then it's just an opinion, but it's not based on your specialized opinion, study, or training. So it stated that he did not give evidence his study or experience permit him to do or to provide anything more than what he called ballpark figure estimation. So what he gave was just an estimation, but he was not qualified to do the measurement. And then himself, when he was questioned, he said that whatever I was given is just an estimation, and it's not like I'm providing evidence on the quantitative and numerical. So himself, he was also not coming out clear to lead the court that the court can rely on the figure he was given. So it stated that a failure to demonstrate that an opinion expressed by a witness is based on his witness specialized knowledge based on training, study, and experience is a matter that goes to admissibility and not its weight. So the moment it fails, then its admissibility test will be impacted. So in this case, it was found that failure, Dr. Bastian's evidence was not admissible. So, and then just to conclude on that, it stated that this case, Dastir and Hausha, is obtaining expert evidence. A party must carefully consider the implication of Section 79, subsection 1, and ask whether opinion given is based on specialized knowledge, expert training, study, and experience. Experts occasionally do speculate in their report, but the practitioner obtaining the expert opinion must be careful to avoid relying on speculation, as the opinion proffered could be inadmissible. Like this case, it was said it was mere speculation, it was not admissible because the opinion he gave was not based on his knowledge, training, and experience. Case that will mark the end of this case, and that's what we found out. And just to add, what happened in this case was that the judge, the tribunal that was adjudicating this case, they relied on the estimation of Dr. Bastian, and the judge actually did some calculations, and that also was challenged. And then what the court found out that the act of the judge relying on the opinion, which was found to be explicative, was not also in order. So it was wrong for the judge to do that, because he was not allowed to do that. And evidence rules were applicable even to the tribunal. So the judge himself relied on an opinion and actually saying that I've been working as a time, I also acquired some knowledge on this area so that I can even do a calculation. It was found also that was not in order. So Malim, back to you.
Thank you, Ariki and Ibrahim. That was well presented. Does anyone have any questions on that presentation? I think it was pretty clear on the background and on the court's decision and why the decision was made. Any questions? And as you're thinking of the questions that you want to ask, just a side note, this is how we'll be doing our CAT. The kind of presentations that we're doing today is what I want us all to get used to, because the CAT will be pretty much this way. There'll be a written element to the CAT, and there'll be a presentation element, the presentation carrying the bulk of the marks, which everyone has to participate in. There shall be no allowance given to someone who says, oh yeah, I helped prepare the written work and I'm keeping quiet for the presentation. Everyone has to present. So there's no choice on that. So you might as well start getting used to it now. That's number one. And then number two, on the presentation, okay, I've lost my train of thought. Sorry, Ibrahim, go ahead while I try to remember what I was going to say next.
Yes, Malim, what I realized in this case is the challenge was raised by the respondent on the admissibility of this evidence, but the judge did not make any determination on admissibility, and also it went to the appeal up to the High Court. So I was asking, in Kenyan context, at what point should determination of the admissibility of expert evidence made? Is it at the basically at what point? Is it at the judgment or at the cross-examination? At what point can determination on admissibility made by a judge?
That's a good question, and thank you, because that question actually reminded me of what I was going to say next. Is maybe I jumped the gun, because we should have discussed why admissibility of evidence is even an issue or a thing that we should be considering in our class. So I put the question to, I'm going to answer your question, Ibrahim, in a second. But first of all, I want us to be on the same page on why we're even studying admissibility of evidence. Why is admissibility important, ladies and gentlemen? Who can start us off there? Because it gives us the context for all these cases that we are going through. Why is admissibility important as lawyers? Anyone? Ngaina? Ngaina, why is admissibility important? Before I give Arike the mic, I'd like you to say something so that I know that we're on the same page. Otherwise, I feel that no one is understanding why we're doing this. Ngaine, I'm talking to you. You can hear me, I know. Okay, Ngaine has decided to drop off the chat. I'll just mark him as absent. Yes, Arike. So yes, Ngaine, are you back? Yes.
I was putting my mic on.
You were checking Google. Okay, go ahead.
Okay, so your question about where admissibility is important, I think it's about you have to look at the relevance of that particular evidence for you to know whether it's admissible. Basically, the relevance of that particular evidence is what determines its admissibility. And I think also the reliability of that particular piece of evidence that you want to present to court. Reliability determines whether that particular piece of evidence is admissible.
Okay, thank you very much. So you've talked about reliance, which I'll say, credibility of it, of the evidence, and also what's the first thing you said?
The relevance.
Relevance, yes, sorry, it's relevance, not reliance. So the relevance and the credibility of the evidence. Arike, go ahead. Thanks, Ngaina. Arike, go ahead. Arike, you're on mute.
Sorry. So I think admissibility is important because it goes to the concept of justice and fairness. Something might be relevant, but it's not necessarily admissible for a myriad of reasons. Sometimes admissibility could go to was the evidence given voluntarily, if it's let's say if it's a criminal case and the evidence, a confession was derived from the witness, from the accused, but the circumstances under which the police or whoever got the confession were suspect, and so the evidence become inadmissible. Or if it's scientific evidence, the evidence could be relevant, but the evidence was not properly preserved. It could have been not terminated, corrupted, or something like that. So I think the importance of admissibility is that it goes to fairness, so that we protect the person on trial, especially in criminal cases. We do the best to protect the person on trial. We only admit evidence that is not going to unfairly prejudice this person and maybe possibly put an innocent person behind bars.
Okay, so unfair prejudice, yes, agreed. And yes, that's a good explanation. Chelsea, go ahead. Chelsea Owino.
Yes, can you hear me?
Yes, you can hear you. Go ahead.
All right, okay. So for me, in my opinion, when I think of admissibility and why it is important when we're talking about evidence, similar to what my colleagues have said, but just to echo on the issue of, competence. I don't think that has been mentioned, but I will talk about competence rather. For evidence to be admitted in court, it must be, competent. And competent in this particular scenario is where that particular evidence is actually going to assist the judges in making, a suitable, I think, ruling, if that's the right way to put it, because you can't
decision,
give evidence. Yeah, decision. Yes, that's the word I was looking for. I know rulings for applications. So when it comes to competence, I think I would liken it to, employment issues. You might have the skills, but it might not be relevant. So similar to evidence, for it to be, admissible, similar to the other things that people have said, I also think that competency is also another reason why we should, admit such evidence. Yes, that's what I would say.
Okay, so, agreed with what you've just stated. And then Fatima, go ahead.
I wanted to say about accuracy, like admissible evidence is typically subject to strict standards of reliability and validity, which means that it is more likely to accurately reflect the truth of the matter at hand, like the facts and facts of the issue that are given. And also another thing is it is important for the efficiency. Like by limiting the evidence that can be presented, the legal process can just be streamlined and made more efficient. That's what I wanted to add.
Okay, thank you very much, Fatima. Ibrahim, go ahead.
Mwalimu, admissibility, I think from my own understanding, it's a bit comprehensive in terms of its approach. It will look at the professional himself who is providing the opinion. It will look at the data. It will look at the methodology. To look at the reasoning, conclusion, and how all these things are linked to the opinion that person is giving to, so that ultimately the property value of that evidence outweighs the prejudicial effect that may arise.
Agreed. So what everyone has mentioned, and thank you everyone for contributing, what everyone has mentioned is actually part and parcel of why admissibility is important. Because it's ultimately it safeguards the integrity of the evidence that's being produced in court. Yeah, just a second, just give me a second, sorry. Beg your pardon, ladies and gents. Sorry, I was just attending to an issue in where I was. Sorry about that. So I was saying, admissibility is to the importance of admissibility is to safeguard the integrity of the evidence that's being brought, so that we don't have just anyone producing evidence that, as has been mentioned by one of you before, that can be used to unfairly put someone behind bars, or on the flip side, to acquit someone who may not be deserving to be acquitted just because of the quality of the evidence that's been given. So it's a very important feature of the adversarial system, which we as a Commonwealth country practice. And therefore, that's why we're discussing it today, and the importance of it as it pertains to law, science, and technology, and to expert evidence that is provided. So to answer Ibrahim's question about when do you bring it up, you bring it up during trial at the first instance. Because if you don't bring it up at the first instance, then it really hampers any chances of appeal, because it was not brought up in the first instance. So for example, I gave you an example of a situation that happened with me personally, where the claimant was claiming that my client, the hospital, had acted negligently during her cataract surgery operation. And she brought a witness, a doctor, supposedly an expert witness. So once I found out that this was a general practitioner and not a specialist on eye health, ophthalmologist, if that's the correct word, or an eye surgeon, I raised that issue about their expertise and how they were not qualified to give evidence about eye surgery. And that's the point where you raise admissibility. So once clarified that their qualifications were not those that would render their evidence relevant or competent, some of the words that have been used and correctly used by the class, then I raised the issue of admissibility before the judge. So that now the judge would give directions, or at least even if they don't give directions at that stage, then in their decision making, it is a feature where they say that, or they acknowledge that that evidence cannot be admissible, because by virtue of the fact that that doctor was not an expert with the training and knowledge specifically related to eye surgery. So that's where you raise it. You raise it at the trial stage, because that's where now all the evidence is being presented to the court to be admitted by the court. Because just because you file documents doesn't mean they've been admitted. They're admitted at trial when evidence is being given. Because for those of you who have you done your clinicals yet? Yes, no, don't know, don't care.
Not yet.
You haven't done clinicals. So now that when you do go to clinicals, because I presume you'll do it at some point this year, and you go to and you're attached to a criminal court, pay attention to how evidence is being presented. So the lawyer will, even in civil court cases, but specifically in criminal matters, the lawyer or the advocate will ask questions of the witness, and then will introduce that piece of evidence through the witness. The witness will say, yes, I know this document, I wrote this document, I received this document, I typed this document, I read it when it was delivered to my uncle, whatever. And then the advocate has to introduce it as evidence, or rather present it as evidence to the court, and will ask the witness, would you like this to be produced as part of your evidence? And the witness will say yes. Almost always they say yes, very rare they say no. And the reason they say no is that they don't know about that document or that evidence that's being produced. And at that stage, the advocate would tell the court, Your Honor, I am producing this evidence, this letter dated the 30th of March 2023. I'd like it to be marked as Plaintiff Exhibit 1 or Defense Exhibit 3, and so on and so forth. So at that moment, it is the duty of the opposing counsel to raise any issues they might have with that evidence that is being produced. And that's where now admissibility comes into play, or admissibility rules come into play. Ibrahim and everyone else, I hope I've answered that question. You've got a clearer picture. Okay. But please, 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 there's nothing like seeing it in practice, seeing it in action. So whenever you do, or you don't even have to wait for clinicals, next time you have free time, go to the Mombasa, or log in. You don't even have to go anywhere these days. Log in to any lower court magistrates matter or high court matter. But I think criminal courts now you still have to go in person. So just take a trip down to Mombasa Law Courts, go to one of the magistrates' courts, and just sit and listen to a trial and see how evidence is produced and how the issue of admissibility of evidence comes into play. I see someone's hand up. Churchill, go ahead.
Yes, I actually have a question, and I'm a bit conflicted with the issue of having an expert, with the term expert, to be precise. So, because when you look at the exception here, talks of specialized knowledge, and the knowledge can be acquired probably through training or study. So when we talk, or even experience. So when we say that, for instance, there's a junior resident working in a hospital, and they are yet to decide on whatever route to specialize, and probably they have been into different surgical rooms. In certain matters, they've assisted their senior residents, that is the specialized doctors, in certain surgeries. In an instance whereby, for instance, let us say that the senior resident doctor is not around, and the junior resident doctor, who is now a general doctor, decides to testify or give out an expert opinion on a certain issue during the time of the happenings of the events. This person was there and was under the guidance of, let us say, the specialized senior resident doctor. So my question is, at what extent do we say that this person is an expert, or this person has specialized knowledge of a certain matter, or of a certain event, or rather to say that they have the experience? Or should somebody have the licenses, the year of practice, and certain things? So what is the threshold to become an expert? That is my question. Thank you.
That's a good question. The simple answer is it depends on the evidence that they're giving. So expert, when I use the word expert, I'm using it in quotes because, as I said, when people think of expert, the tendency is to think of professors and scientists, when really what we're talking about is, and based on Rule 76 on opinion, is based on training, study, or experience. You can have experience without being trained, or without having formal education. Like, for example, an artisan, a plumber, an electrician could have the requisite experience without necessarily having gone through formal training. They could have just been, they could not just been, but they could have been, what do you call it? They could have been a trainee. They could have been, there's a word for it. Apprentice. Thank you, Ibrahim. Apprentice. Okay. They could be an apprentice. They could be all sorts of things. So it doesn't, when we talk about expertise and training and knowledge, please do not limit it to people who are professors or scientists or that kind of thing, because that would be too limiting. And that simple answer to your threshold question is it depends on the evidence that's being tendered. So someone could be a resident, a first year, junior resident, etc. And their expertise would be fine as long as they're not giving evidence of something that is beyond their experience, beyond their training, beyond their knowledge, beyond their study. That's the threshold. You stop becoming an expert witness when you're giving evidence that goes beyond what is beyond your capability, beyond your training, beyond your experience. That's where the threshold stops. Have I answered your question? Hello? Am I on mute? No, I'm not on mute. I'm unmuted.
Yes, yes, yes.
Are you there?
Yes,
Yeah.
I'm there. I'm good. Thank you very much.
Yes, so basically it just depends on, basically the threshold is, are you giving evidence within your knowledge, within your sphere of knowledge, or are you giving evidence beyond? Once you start giving evidence beyond, you stop being an expert witness, and that just becomes, that becomes inadmissible. Or at least the opposing lawyer on the other side should be able to pick that up very quickly and challenge your capacity to give evidence purporting to be expert evidence based on the threshold, or rather the scope of your knowledge and training and experience. Okay, that's a good question. So you need to be aware of it. You need to be, as a lawyer for the other side, when you are trying to challenge evidence that's being tendered, you need to be aware of all the witnesses, you need to be aware of their qualifications. Hello, I'm back. Can you hear me? I think I got thrown out of the meeting. Can everyone hear me?
Yes, yes.
Yes, we can.
Okay, thanks. Apologies for that. Well, what was the last thing you heard me say, so I can continue from there?
You've responded to Churchill's question, Mwalimu, so you are to go back to the slide.
Okay, all right. Thanks, Ibrahim. So yes, so on that note, let's go back to the slides, or go back to the next case rather. Who had Haniset versus the Queen?
I did.
Thank you. The floor is yours, Chelsea.
Okay, thank you. So the Haniset versus the Queen, it's a 2014 case. I'll just go through the brief facts of the case, and then what the court determined, and then I would look at the principle that was highlighted, etc. It's quite a long case, but I'll try and make it short yet detailed. So the brief facts of the case.
Just give us give us a brief facts, and then just focus in on the issues. Yeah. Thanks.
Yes. I think I'll be very, very brief. So in September 2008, a person by the name Anthony Haniset, alongside two other people, entered a certain hotel in Sydney's Northern Beaches, wearing dark clothes with a white pillow or t-shirt wrapped around their heads, and they were carrying a hammer and a shortened shotgun. So Haniset, alongside the other two people, confronted the employees of the hotel, supposedly, and stole nearly $5,000 in cash and then they escaped in a stolen Audi RS4, which bore separately stolen numbers as well. So Haniset was charged with armed robbery in the NSW District Court, and the prosecution case was largely circumstantial, and it relied on a few different ways of connecting Haniset to the armed robbery, including DNA comparisons. The most controversial piece of evidence, however, was that of an anatomy expert from a certain university, the University of Adelaide. And this robbery had been captured on CCTV footage at the hotel. So Professor Henberg, who was the one who was giving the expert opinion from University of Adelaide, watched this footage first. And, he then drew the conclusion that there was no anatomical dissimilarities between the two individuals. And this particular evidence given by that certain professor was what was used by the prosecution to argue that Haniset was actually one of the robbers of the hotel. So Haniset goes ahead, the trial continues and whatnot. And then Haniset is found guilty and sentenced to 8 years in prison with a non-parole period of 3 years and 10 months. Due to the fact that he was not satisfied with this particular judgment, he went ahead and appealed against this conviction. And upon appeal, it was argued by, the court, not argued really, but it was held that Professor Henberg's opinion did not fall within the exception in section 79(1) of the Evidence Act. And this is regarding, admissibility of evidence. So in this particular case, the Court of Criminal Appeal agreed with the trial judge that Professor Henberg's evidence was admissible because it was evidence of an opinion that was wholly or substantially based on his specialized knowledge within the meaning of section 79(1). So then now this particular court, after the appeal, that is, because it was a high court matter and then went to the next stage, which is the Court of Criminal Appeal. So this particular court quashed Mr. Haniset's conviction and ordered a new trial. So this new trial is where everything really happened. And in this new trial, the court was obligated to decide whether the trial judge had erred in admitting expert opinion evidence, which is that of Professor Henberg, or not. So that was the whole basis of the appeal. And I believe this is now where what we're learning in class sort of relates to this case. And in this case, the High Court unanimously allowed the appeal, stating that expert opinion was not based wholly or substantially on specialized knowledge within, and that it was an area of law to admit the evidence. So this particular court considered the relevant provisions in the Act, and it went ahead to define what specialized knowledge is. And along the same lines of what specialized, I'll just read it. It's a very brief paragraph. It says that knowledge which is outside that of persons who have not by training, study, or experience acquired an understanding of the subject matter. However, the person's training, study, or experience must result in the acquisition of that particular knowledge. And then they go ahead to say that the opinion evidence in the latter case was found to be inadmissible. So what they did, this particular court, the High Court in this case, hearing the appeal, so it was the Court of Criminal Appeal, and then this one, the High Court. So in another case, which is Tang and Morgan, the same Professor Henberg went to give his opinion evidence, but it was found to be inadmissible. So I believe they were looking at the doctrine of precedence and seeing what did another particular judge say in this particular case, and they were using that for this. So the court was very critical of the degree of specialized knowledge involving the field of body mapping, and so it was not persuaded that the comparison of the images of the offender with those of the appellant was a task which the jury would not have been able to undertake for themselves. So in this essence, the court was just trying to say that we did not see a need to bring in Professor Handberg if the reason behind him coming in was to basically identify the image of the offender with that of the appellant. And they felt that this was something that could have been handled in-house without bringing in someone from outside. And then there's also, the High Court also addressed the assessment of Professor Handberg's evidence at trial. And one of the judges, Judge Buzik, held that this evidence was admissible because evidence of similarity between offender 1 and the appellant was of potentially significant probative value. And then the same High Court, so now this is before the High Court, that is, the appellant challenged the assertion that, a subjective opinion was based wholly or substantially on specialized knowledge, was not really amenable to measurement and calculation. And then the same court maintained that the legitimacy of body mapping as a specialized field of knowledge was not an issue on appeal. Rather, the issue was whether Professor Handberg's conclusion were based on his knowledge of anatomy. And they said that Professor Handberg's conclusions were not based on the knowledge of anatomy, but rather the subjective impression of what the professor saw when comparing the footage to the recordings and still images of the appellant. And I think that this relates strongly to whatever we're learning in class on the issue of expert opinion evidence. And I believe in the last class, when Mr. Sige was just taking us through, he mentioned in summary after students had contributed that, expert opinion evidence should be non-biased, it should be impartial, because now when Professor Handberg was giving evidence not based on his specialized field of anatomy, it looks like he was giving evidence on a subjective basis and not an objective basis. And that is why his evidence was not really taken on record by the High Court. And a good example of that is his assertion that offender 1 and the appellant were both right-handed. And this was based on offender 1's use of his right hand to remove cash from the till and the appellant's right-handed method of writing his name. So for them, they believed, the court that is, believed that whatever Professor Handberg was giving to the court was not really based on specialized knowledge, but I believe it seemed like something that, anybody else could have done, which is why they said even the jury could have been able to identify that. So the court, as I wind up, validly pointed out that the professor's use of technical terms had the effect of giving the appearance of scientific grounding to an otherwise basic task of observation, and arguably the jury was capable of making their own observations and coming to the same conclusions without the need for expert evidence. As such, the High Court held that Professor Handberg's opinion was not based wholly or substantially on his specialized knowledge within Section 79(1) of the Evidence Act, and that it was an error of law to admit that particular evidence.
I think that was very well presented. Again, I'm happy with the presentation so far. Those who haven't presented, now you see the standard. Kindly keep the standard at that level, or even better if you can. So thank you, Chelsea. I really don't have much to add to that. Does anyone have any questions on what has been presented on specialized knowledge specifically, and how the court has interpreted what specialized knowledge is? Yes, Chelsea, your hand is up.
Yes, I have a question regarding the case and regarding the specialized issue. Because as I was doing research on this case, I noticed that, in the judgment done by the High Court, where they were saying that, they just brought him in on appearance, that, this is an expert, so he's bound to give us expert evidence. But then the moment he speaks, he doesn't really give evidence that is specialized, anatomy. So my question is, before judges or before courts bring in experts to come and give evidence on a particular issue, is there a test that, you know, this particular experts are subjected to, similar to that of witnesses when they're being tested on their competency or their mental capacity? So is there some sort of test that is done that way the court is able to know if this person is actually knowledgeable on the matter and if his knowledge can be used to help decide that particular case?
That's a very good question. As I said earlier, our New South Wales is also a Commonwealth country, therefore it has a similar system to us in that they practice an adversarial system. So when it comes to experts, what should be understood, or rather what should be very clear to everyone, is that the experts are not brought by the court. You know, in an inquisitorial system, such as, you know, France, Germany, Italy, the court actually would take the initiative to call an expert to assist the court to make a decision. But in an adversarial system, such as ours, England and Wales, Australia, etc., the expert is brought by either side, the lawyers and bring the expert. So the plaintiff will bring their expert, the defense will bring their expert. So now there is no test, and really what it boils down to is the skill of the opposing lawyer in showing the court that such and such expert brought by the other side does not have the knowledge, the training, or the experience to give evidence on whatever issue is actually at hand, that is before the court to decide upon. So that is the, well, fortunate stroke unfortunate circumstance that an adversarial system has, is that there is no real test before any counsel brings a witness for the court to give evidence. What really it relies upon is the skill of the opposing lawyer in exposing their lack of training, knowledge, and experience to give evidence on whatever particular issue is before the court. All right. Ibrahim, you have a question? I hope I've answered that question, Chelsea.
Yeah, yes.
Ibrahim, you have a question?
Not really a question, but just a kind of remark. When Chelsea was presenting the case, she mentioned that whatever the expert was presenting is kind of common knowledge, that the jury can do that determination themselves without any assistance of any expert. But then my thinking is, if this expert now is expected to use certain machines and certain methodology, and this particular expert is not methodology that is expected to be used by the people or the profession of his caliber, then if this particular one, his anatomic background or certain tools to make inference from the case, rather than using his the kind of observation he was making, that would have changed the perception of the judge in terms of holding that his was just observation, that without even him, the jury, if he was using some machines or methodology that anatomic people from that background would use, and that the jury will not have that sophistication to if they were using those machines that expert would use.
Okay, I think I've understood you, Ibrahim. I think you're trying to make a distinction between what is common knowledge and specialized knowledge in the example that you gave. Yes, okay, I've understood you correctly. Yes, in fact, what I wanted to add, the only thing I would add to Chelsea's presentation is that there's a definition by Blackman Jay's formulation in the Dober case, which we're going to talk about later, where the word knowledge connotes more than subjective belief or unsupported speculation. The word knowledge connotes more than subjective belief or unsupported speculation. So that when you're bringing an expert, they're not just coming to rehash what anyone else would say about a certain situation. They have to bring their specialized knowledge to the table. It has to be relevant, it has to be credible, and it has to assist the court in coming to a fair and just decision. So knowledge applies to any body of known facts or to any body of ideas inferred from such facts or accepted as truth on good grounds. Okay, So it has to be applied to a body of known facts or known ideas inferred from such facts, or accepted as truths on good ground. So we have to distinguish what is common knowledge from specialized knowledge when you're looking at a so-called quote-unquote expert witness, because it does no good to the court for an expert to come and give evidence on what can be, what would be considered common knowledge. It adds nothing to the table, and therefore it then becomes opinion, and then opinion really is not admissible. And that's the general rule under Rule 76 of the New South Wales Code. Okay, I think I had, and Chelsea, you have a question?
Not really. I was just going to briefly respond to what Ibrahim had said.
Yeah, sure, go ahead.
Yeah, just as per the case. So I think I skipped that part because of trying not to say much. But when the professor watched the image, his conclusion, like he did the thing of the physical characteristics of the person in the footage, reading out the features of the non-person, etc. And then he did a list and whatnot, trying to put his list together alongside the two individuals there. And then the High Court said that you don't really need a doctoral degree to be able to identify the physical features of a person. And they were even saying that if a person has an oval-shaped head in a particular photo, the jury will be able to see that particular feature without any need for bringing in an expert to identify that. And he was even saying the thing of the person being right-handed and how the appellant was the one who was removing cash from the till using his right hand, and that his posture on the CCTV footage, showed that he was right-handed. So on the same, they also say that such evidence given by Professor Handberg should not have been allowed in court. And I think that's just what I wanted to add, regarding the case to what Ibrahim had just said.
Thanks, Chelsea. Actually, you've touched on an important issue, because in this case, we're looking at video evidence. And video evidence, when the jury was being asked was to look at the video evidence and determine whether that person in the video was the person before them, and so on and so forth. So really, all you need is your eyes to determine that. And what the court was saying is that bringing the expert to determine what can be plainly seen by someone's eyes, what was the mischief that the court was trying to correct in this situation? We've touched on it earlier on when we started talking about expert evidence.
Malimo,
what was the mischief? Yes.
A mischief,
go ahead.
Because of his professional standing, he could influence the jury now, because he's the expert who's saying this, then they will just be swayed to agree with him.
Exactly. That was now the mischief that the appeal court was trying to rectify, because what it does, you bring an expert to say, oh yes, they're right-handed, this, that, the other, and because they're called Professor so-and-so, Dr. so-and-so, the jury stops trusting their own eyes and just defers to what the expert says. So then it removes the onus on the jury to actually make sure that they are either acquitting or convicting someone beyond reasonable doubt. Isn't that the threshold for criminal matters? It has to be beyond reasonable. Is it not beyond reasonable doubt? What is the threshold for criminal matter? When you're convicting, it has to be what? Ladies and gentlemen.
I believe it should be beyond reasonable doubt.
Yes, beyond reasonable doubt. I was just checking that everyone is awake. So yes, it is beyond reasonable doubt. Whereas in civil matters, what is the threshold? Ladies and gentlemen.
On a balance of probability.
On a balance of probabilities. Thank you, Chelsea Wanjiru. So yes, so you have to be very aware of that. So when the threshold is as high as beyond reasonable doubt, and then you allow an expert to take the job or the task off of the jury or the decision maker by putting their credentials and their Dr. so-and-so, Professor so-and-so in front of them, to remove that job from the jury, then that conviction or acquittal becomes unsafe, because the jury did not do anything. They did not actually acquit or convict beyond reasonable doubt, because that job was taken off of them because they just blindly believed what the professor was saying or the so quote unquote expert was saying. So thank you for that, Chelsea. Okay, we have our next case, which is Hillstead versus Regina R. Hillstead versus R. Who was doing that one? Hillstead? Hello? Who was doing Hillstead? Okay, I take it they have not prepared themselves, and yet I know I issued that Hillstead. But anyway, we'll find out who it is. Who was doing To It versus the Queen? Thank you, Bosco. The floor is yours. Oh, sorry. Yes, yes, you can. Go ahead. Sorry, I muted myself without realizing. This is what I like. Now, Bosco is raising the bar here. So the one coming after Bosco, you need to come correct. Thank you, Bosco. This is how it's done. Go ahead. You've upped the ante. Mm-hmm. Thank you very much, Bosco. Very good presentation. If you were in class, I would have asked everyone to clap for you. Keep this last slide on. There's something I want to add on to that. Everyone, if anyone has questions for Bosco's presentation, any questions, anything you've not understood? Any clarification that you'd like to seek? This is actually the style in which we do CATS. When a presentation is made, everyone has a chance to ask questions, clarify, or add on to it. And people get marks for that. Or rather, I mark. I don't know about other lecturers, but I give marks for that. So this is your chance to exercise that muscle. Go ahead, Ibrahim.
And quick one, because you mentioned section 79, subsection 1. Of course, it talked about an exception to the general rule that is indicated on opinion evidence. And here it is, here you're talking about a novel or inference drawn from facts that have not been tested by others. They're not mentioned in the section. I don't know whether this was the court using to arrive at this kind of conclusion that even if it's novel or untested, it's still a good evidence. What was the basis that, is it prudence?
Thank you, Ibrahim. Bosco, do you have a response to that? I will also add to that. Yes, I'll add to that. Thank you, Bosco. Thank you, Ibrahim, for that question. It's actually a good question and is leading to what I wanted to add. Because if you go through that decision, also what the courts, there's a proviso to what is on this slide, which is why I asked for it to stay up, that a person's knowledge may qualify as specialized knowledge, even if the area of knowledge is novel or inferences drawn from the facts have not been tested or accepted by others. There was a proviso to that. The court stated in Hillstead that there is a duty, like there's nothing that stops a new novel area from of expertise from being admissible, as long as the person giving that expert testimony gives the trier of the fact or the judge or the decision maker the criteria to enable the evaluation of that expert conclusion, especially when it comes to areas that are still new or are yet to be established or as accepted or what's the word, not accepted, but my English is failing me today, as a given position. Yes, Arike, help me out, please.
I would say it goes back to that that thing where we got from the first case, the way 79(1) is constructed, that the evidence must contain the statement of reasoning, so that it's not necessarily just the expert saying, okay, this is what I tested and then this is the conclusion. What you're talking about, the criteria, the expert will show step by step, they will show the judge how this is how I applied my expertise, this is the reasoning, and then I arrived at this conclusion this way. And the case, I think they also say that section 79(1) provides its own way to test the expert evidence, so that it could be that this person is a new expert in that field, and if section 79(1) accepts that this evidence is it's admissible, then it would be a disservice for, as Bosco mentioned, the coming cases, if the judge were to rule it out based on the fact that it has not been tested or accepted by others, because things have to start from somewhere. So I think what you mentioned, it just involves the reasoning rule, that the reasoning is within the evidence. So the judge has a way to see, okay, this is where you're coming from, then this is where you arrived at, and then although it's novel, the reasoning makes sense to me, so I can admit it and apply it.
Very well put. Thank you very much. Yes, I agree with everything Arike has said, but just phrased it better than I had it in my mind, or I was trying to take out of my mind and into a speech. So the court has to be convinced that the expert evidence that's being given is reliable, and it has to be established to the court's satisfaction. That's under section 137 of the New South Wales law. So once that the court is satisfied and the criteria is given as to how the expert came to these conclusions, what tests were carried out, why those tests were carried out, what was trying to be established, then once the court is satisfied on those grounds, then it is able to admit or rather to actually properly consider the evidence that has been brought before it, and then determine whether it is admissible to help the court come to a decision. Okay, right. Thank you, everyone. Thank you, Bosco. You can put your slides down. Thanks very much. That was good. Right. So when it comes to practice directions, expert evidence in criminal trials, and that is in Victoria, which is another state in Australia. Let me put the slide up. And this is just coming from these 4 cases that we've discussed. Well, not really Hillstead, because the person who was supposed to present Hillstead has conveniently kept quiet, but I'll find you out, don't you worry. So you better let yourself be known now before I find you out, because when I find you out, there'll be hell to pay. So let me put this slide up. I hope you can see the slide. Can you see it? If you can't see it, say something. If you can see it, say something. Okay, great. So according to these practice directions, the purpose is to enhance the quality and reliability of expert evidence that's relied on by the prosecution and the accused in criminal trials. I want us also to think whether we have similar practice directions in our Kenyan law as well, because we want to compare and contrast so we can understand where our Kenyan law is when it comes to admissibility in comparison with other jurisdictions. So the purpose of these practice directions when it comes to expert evidence in criminal trials is to enhance the quality and reliability of expert evidence relied on by the prosecution and the accused when it comes to criminal trials. The expert's duty to the court, number 1, is that the expert has an overriding duty to assist the court impartially by giving objective, unbiased opinion on matters within the expert's specialized knowledge. Very much like an advocate has a duty to be as a duty to the court first and foremost before even the duty to their client. But as we know, in this adversarial system of ours, sometimes the lines can become blurred as to who has the which is the overriding duty. When it comes to an advocate, then the same I suspect could be said of expert witnesses because of how they come to court. They are not brought by the trier of fact. They're not brought by the judge or the magistrate. They're actually brought by the parties. Whether it's the accused or the prosecution, they're brought by one party or the other, and now it's up to the court to make sure that whatever evidence is being brought, they understand that their first and foremost, their duty is to assist the court, and that's an overriding duty, regardless of who has brought them to the court. And the second is that this duty overrides any obligation to the commissioning party or to the person by whom the expert is paid, just what I was mentioning earlier. So there can be that kind of conflict, but what is supposedly understood is that there is an overriding duty to the court that has to be, that is given by the expert, regardless of who has commissioned them, regardless of who is paying them, so that there are consequences if they breach that overriding duty. All right, Ibrahim, go ahead.
Malim, an expert, they are supposed to be umpires. If now a defendant, he profiles, witness profiles evidence which tends to harm the interest of the defendant, that will be prejudicial to the defendant. Will it, and it's admissible, it's found to be admissible. How will that, because he's found to be unbiased and assistance may harm his client, maybe. Will it be not the rule on the principle of confession or something like that will come in?
Not really confession. What is the way around that? Even as lawyers, we have an overriding duty to the court, but there is still a way to get around that. What is expected of us as lawyers is not to lie, not to willfully mislead the court. But what can lawyers do instead of lying, which is obviously a breach of that overriding duty? What would you do instead?
Because Malim, on the data this opinion expert is presenting, it is the defendant who made it voluntarily.
Okay, so in your scenario, Ibrahim, who's producing the expert witness?
It's a defendant. It's a defendant who's getting the data, and then whatever evidence now is caught, it may harm the interest of the defendant. So, and that evidence, whatever data he's working, the foundational data is provided by the defendant to the expert. But it so happened that whatever opinion is may harm his client.
So now what would you do as the lawyer of the defendant when you've got that report from your expert witness? What do you do?
I will probably discredit or
would you allow your expert to give all that information, which part of it might harm your clients? What tends to happen in practice? What would you do? And this is a safe space. I'm not going to ruin your chances of becoming a senior counsel in the near future. But what would be a lawful way to deal with that situation without breaching your overriding duty to the court and the expert's overriding duty to the court?
I think you will not include his evidence as part of the evidence you will be presenting to the court.
Yeah, that's basically what tends to happen, is that you just don't include it. So you've not lied, but you've just omitted to bring it out. And because it's an adversarial system, it's up to the lawyer for the prosecution, or rather the plaintiff, to figure it out and to let the court know that there's some missing information from what has been tendered by the expert. And also, as you are examining your witness, because that's your witness, the expert, you would examine them in a way that they do not perjure themselves. So possibly what you do is ask questions, but avoid asking your expert questions on those very issues that you think might be damning to your witness, who's the defendant. So that also you do not end up causing your expert witness to perjure themselves and thereby breaching the overriding duty to the court. Okay, that's one way. Please don't need to be said I'm trying to teach lawyers to become crooks. No, that's not what I'm doing at all. But I'm just saying that's one way of dealing with that situation, because ultimately it is an adversarial system that we are in. If it was an inquisitorial system, then this would not even be an issue. But because adversarial, then number one, you have to walk that thin line of not willfully lying to the court, i.e. saying things are true which are not, or saying things are not true when they are. But then what you do is try to smartly, without perjuring your witness and also without breaching your overriding duty to the court, you have to smartly avoid those issues in that expert testimony or report that might be harmful. Or a better way, I would say, is to preempt the damage. So you would not wait for that damning information to be released by the other side, you would self-inoculate, if that makes sense. I would release it myself and find a way to spin it to my client's advantage, rather than keeping quiet about it and avoiding it, because it always sounds worse when it's brought up by the other side. So it's better for you to deal with it, preempt it, and rebut it yourself, rather than avoid it altogether and then leave it for the other side to make it sound even worse than it would have sounded if you had revealed that information yourself. Because there's no evidence or testimony that is super clean or perfect. Of course, there'll be parts of it that might not help your witness, but the best way, what I would do personally, is to minimize the damage myself by releasing it myself, and then finding a way by preempting it, and then finding a way to soften that blow or mitigate that damage that report might have said. So that's my best advice. Hope I've answered your question, Ibrahim.
Yes, Malim, thank you.
Okay. Yes, so those are two options I've given, and I've told you the most preferred option. So do with that information as you will. So in those practice directions, so we've got the overriding duty, okay, that part. So with these practice directions, all experts' reports shall state the opinion of the expert and shall specify or provide, and there's a long list of these, but what I'm focusing on is these that I've put on the slide. Please go and read these the practice directions at your leisure and be aware of them, because this is I want you to have this in mind when you're thinking about our own legislation and our own jurisdiction and how we deal with expert opinion and expert reports and expert evidence. So one of the things that these practice directions say that an expert evidence or report should provide is whether and to what extent the opinions in the report are based on the specialized knowledge, training, and study on which that specialized knowledge is based. It's almost like giving some sort of certificate, okay, that this opinion I'm providing or this report I'm writing is 100% based on my knowledge, training, on my training, study, and expertise. It should also state the material, observed facts, reported facts, assumed facts, and other assumptions on which each opinion expressed in the report is based, and a letter of instructions may be annexed to that effect. So you have to the expert has to clarify what is a material fact, what is an observed fact, what is a reported fact, what is an assumed fact. So the judge is very clear on what weight to put on what facts that the expert is giving evidence about. Also, the expert report must state that a particular question or issue or matter falls outside of the expert's specialized knowledge. So they should basically tell the court that, okay, up to here, I have expert knowledge on it based on my training, study, and experience. Beyond that, I have no specialized knowledge, and therefore I cannot comment or give any opinion or expert testimony on the same. It also states the practice directions, still on the practice directions, also states that such a report by an expert must show any examinations, tests, or other investigations on which the expert has relied, identifying the responsible lab by which and the relevant accreditation standard under which the examination or test or investigation was performed. It also goes further to say that all expert reports shall state, specify, or provide any qualification of an opinion expressed in the report, without which the report would or might be incomplete or misleading. It also says that any expert report must state any limitation or uncertainty affecting the reliability of the methods or techniques used or the data relied upon. It says that such a report must state any limitation or uncertainty affecting the reliability of the opinions in the report. For example, there's insufficient research in that area, or there's insufficient data in that area. All right. And Finally, practice directions where an expert is aware of any significant and recognized disagreement or controversy within that relevant field. To the expert's ability, technique, or opinion, the expert must disclose the existence of that disagreement or controversy. So these are the Australian practice directions on the level or the standard of expert reports when they're being provided to court. So these are the checklists that the experts have to make sure are provided for in their report. So now my question becomes, ladies and gentlemen, what is your awareness? Do we have a similar situation or a similar requirement under Kenyan law when it comes to expert testimony? Discuss. That could be your exam question. So let's discuss. Do we? Do we not? To what extent are we similar to these Australian the practice directions? To what extent are we different? Here we go. That's your exam question. It has been put in front of you today. Would you be ready to answer it and get full marks? And that's a 25-mark question. In LST, you have to answer 3 out of 5 questions. The first question is compulsory, and that is 30 marks. The second and third question that you pick out of the remaining 4 come up to 20 marks each to give you a total of 70 marks, and your CAT is 30 marks. Would you be able to if this was the compulsory question, would you be able to give a 30-mark worth answer? Ladies and gentlemen, Franklin, discuss this. What are your thoughts? And give me intelligent thoughts, please. Franklin Makanga?
Yes, Mwalimu.
You heard my question.
Yes.
Let's discuss. After going through what this jurisdiction requires of expert opinion evidence or reports, and with your knowledge of what happens in Kenya, what are your comments? What is your analysis? I'm just throwing it out there because that's the kind of exam question that you'd be given, or even CAT.
One of the things, Malim, that comes with the expert's opinion is that at times it's a bias depending on how the one who is accused or the one that the evidence will be working against, how connected they are. So sometimes the expert's opinion is also biased. So it may not be relied. It may not be accurate as a part of the criteria to have it admissible. Those are my thoughts. Yeah.
Okay. What are you basing that on? Is there any? Is that what you've just stated based on a specific act, a specific subsidiary legislation, or is that something that has been mentioned in case law? What are you basing that on?
Okay, with what we have seen happening in our judiciary system, many times the evidence that is admitted is geared towards having a case lost, and when a time comes, now there's the real evidence that needs to be admitted so that the case can be strong. Then whoever is accused goes out of their way, meet the judges or those who are behind the case to have everything compromised. So the opinion from the experts, my position remains that we need to have laws that will make it very difficult to have the evidence compromised as far as it has already been admitted in court. Yeah.
Okay, I take your point, Franklin, and I don't want to really go into what happens in those corridors when things of a nefarious nature happen, such as trying to fix cases or bribe people and judges, etc., etc. But I want us to limit our discussion to what is existing as far as the Kenyan law is concerned, because that's what you'll be tested on. I want to avoid, and actually I'm glad that we've started on this note so that I can just reel everyone in. And because sometimes I tend to see in the exam answers, people go off on tangents and forget that we are still in doing a law subject, a law unit. So we have to always, whatever it is that you say, give examples, yes, but always base it on the law, whether it's a legal opinion, whether it's a case decision, whether it's legislation, etc. Please make sure you're based on the law, because otherwise you end up losing marks and then you don't focus your answer on what it is you're being asked. So with that in mind, I want to take that same question to Donald. Donald, let's discuss. We have seen these practice directions and you know what the Kenya situation is. When it comes to law, what are your thoughts? And I want you to back your answer up with something legal.
So I hope I'm audible enough.
You can be heard very clearly.
Yes, so basically I can say these practice directions are really deep, and honestly to the length of my research and everything, I don't think I've come across an area of law in Kenya that goes into detail on issues to do with expert evidence. And I believe, and I stand corrected because I honestly have done my research on such issue. But then I think if at all we are to rely on such things, then maybe we check them out from other Commonwealth jurisdictions like this one. I don't think there is a tangible Kenyan law that explains on the evidence.
Okay, Donald, you are kind of getting there, but I want us to approach this methodically, and I'm coming to class rep Ronald. Where do we find where are the Kenyan laws on admissibility found? Because that's really where your starting point should be in answering such a question. Where's the starting point? Where are these laws, or rather the starting point should be where these laws are found. So, Ronald.
Yes,
Obongita, Dots.
Yes.
Where are the Kenyan laws on admissibility found? I want sections, I want rules, I want something.
I think for me, I'd start by saying that indeed there is a correlation between what you just taken us through and our local laws. And at this point, I'm looking at the Evidence Act on opinion. I think it's part 9, section 48 and section 49 talks about opinions of experts. Section 48, subsection 1 and 2. And section 49. So allow me to read section 49 specifically, which talks about facts bearing upon opinions of experts. And it says that facts not otherwise admissible are admissible if they support or are inconsistent with the opinions of experts when such opinions are admissible. My point is the law, the Kenyan cases are supported by the law, and in this case, the Acts of Parliament. However, we know again that locally there is a lot of influence, and as my colleague has mentioned earlier, the experts in our jurisdiction of the within our legal system are easily or are prone to or can easily be compromised, and as such, again.
Okay. I'm going to pause you there. Don't go that. Come back from that road. Come back to the main road, please. Let's stay away from that. I want us to build something, an argument, a tangible legal argument. So yes, you've mentioned the sections. You've mentioned section what? Say it again. Section 48.
Section 48 and section and section 49.
and 49 on expert testimony, because we're talking specifically about expert witness testimony, right? Expert evidence.
Yes, and 48 subsection 1, if I can read, says when the court has to form an opinion upon a point of foreign law or of science or art, or as to identify or genuineness of handwriting or finger or other impressions, opinions upon that point are admissible if made by persons especially skilled in such foreign law, science or art, or in questions as to identify or genuineness of handwriting or fingerprint or other impressions. And then 2 says such persons are called experts. So I think there is a correlation between what we are discussing and our local statutes, or about the same.
Okay, good. Sawa. You've started us off, and that I want us to stick on that lane. Now I want to go to, there's someone here that I'm looking for. Okay, I think people have started to fall off when they think I'm going to call them. Fatima, thank you. So now we've started with section 48 and 49. Is there any subsidiary legislation or any case law that you can add to this when we're coming to Kenya's position as far as expert testimony is concerned? We've been given section 48 and 49 of the Evidence Act. Is there any subsidiary legislation you'd like to add to the mix, or any case law that has tried to discuss or to interpret the role of an expert witness or expert testimony or expert evidence? Fatima?
So far, let me just be honest, I haven't, but there is this civil appeal of 21 of 2017, where there is the opinion of the expert witness is not binding on the court, but it is considered together with other relevant facts in reaching a final decision. There is criminal appeal 83 of 2015 that talks about expert evidence that is given by a person skilled and experienced in a professional arena, or any knowledge to guide on the conclusions. Any other, I don't know, but there's also civil appeal 68 of 2019 that is more of like criminal appeal 83, because they all gather about expert evidence, which should be tested against non-facts, since it is the primary factual evidence that is of greatest importance when we are talking about expert testimony. That's all I have to add.
Okay, that is actually quite a lot. And I'm glad so now, from the beginning till now, when we're discussing that question, we have established section 48 and 49. We've been given some good case law. Any subsidiary legislation, case law by Fatima, any subsidiary legislation we should consider as well when it comes to establishing what Kenya's position is when it comes to expert testimony or expert evidence? Subsidiary legislation? Ladies and gentlemen, I saw someone's hand up. Arike, was that you?
Yes, but I wanted to talk about case law. And right now I'm trying to see if the civil procedure has anything to say about it.
Okay. Oh, you look at the Civil Procedure rules or act?
The rules.
Okay. And what about the Criminal Procedure Code, the CPC? Does it say anything about expert evidence?
That one I have to Google because I don't have it physically. But if I find it, I will write on the chat.
Okay. Anyone else who would like to assist? Wanjiru, Chelsea, Ngaina? Any subsidiary legislation? We've talked about the Civil Procedure rules and Criminal Procedure Code. Anything there that might give us some sort of insight into our position as Kenya when it comes to expert evidence? Well, this is how you build an argument. Yes, who's speaking? Yes, Ibrahim.
What about there is a Gazette Notice number 189, and this is a practice direction to standardize some procedures in the High Court. So I'm looking at if witness, there is witness statement also there. I don't know whether that also is part of, because this one
It
has
could be. It could be. It depends on the question. My question is general on purpose, so we can consider as much as possible, and then we can determine, okay, this is relevant, this is not relevant. We can put that into the pot. Why not? Does the Gazette notice talks about? Does it try to address the issue of expert evidence, or does it just talk in generalities when it comes to witness evidence?
Yeah, let's read one or few lines there. It says, this is number 7. It says, the real issue dispute considering in advance issues relating to any regarding admissibility of any documentary, technical expert evidence, pre-recorded digital, electronic evidence, including confession. So this about pre-trial, issue of pre-trial, and all these things should be handled. I think it comes under pre-trial. So they're talking about pre-trial where those expert things is mentioned there. And the direction also in hearing.
Okay.
Yes.
All right, thank you for that. I see Chelsea go, both Chelsea. So Chelsea Owino first, and then Chelsea, put your hand down. Chelsea Wanjiru next. Okay, Chelsea Owino go first, and then Chelsea Wanjiru go next.
Right. For me, it relates to an article.
Oh, Chelsea, I think you have two devices on. There's an echo.
I think now I should be okay.
Yes, now you're fine. Yes.
Yes. So I came across an article that was talking about, the Kenyan court's relation to awarding damages on the basis of expert evidence. And I think I came across this article on LinkedIn. It was written by an advocate who has some sort of expertise when it comes to dispute resolution and whatnot. And in his article, he referred to the case of 7 Seas Technologies Limited versus Commission of Domestic Taxes, which is a High Court of Kenya case. And this particular case related to a tax dispute between a technology company and KRA, relating to a dispute regarding payment of taxes on copyrighted software. So this particular technology company hired an expert on software related technologies who gave an expert testimony on the tax liability in relation to copyright, while KRA did not really see any need to provide any additional evidence aside from what they had given to the court, which was a testimony of the revenue officer who assessed the tax that is. So in the end, the High Court ruled in favor of the technology company, which is 7 Seas Technologies Limited, based on the strength of the expert testimony. And so this article was sort of like a reply to another article that was written by someone, I think, in the media. And in this particular, article, the lawyer now responding was talking about how, courts sometimes tend to look far and wide for evidence that sometimes might be misleading. And at times it is upon the clients who intend to prove their case in court to present such facts and expert testimony in court. And then there's also the issue of how lawyers should come in sometimes to give their clients advice on the basis of expert opinion and how that is, a better strategy. But then they should also tell them that this, like when you bring in, this experts to come in and give an expert opinion, they need to be well versed in that particular area. And they should also look at the cost, because sometimes people go for experts, but then they don't really go for the real experts. They go for those who are considered to be cheap, who might not really, give them value for their money. So you're saying that as clients are looking for, the experts to come and give the expert opinion, evidence, they were saying that they should also be willing to part with, some high cost. That's something I came across some time back. I believe that it might be of benefit to this particular class and the topic at hand.
Okay, thank you, Chelsea. Chelsea?
I'd gotten some cases that we can compare with the practice directions we'd seen, only to realize later that they're not Kenyan, but I can still read what because what you said.
Okay.
In Amcha Passenger Transport Limited versus Helical Bar PLC, the judge stated that laid on the following principles in regard to expert evidence, that the questions to be determined are whether the person or the expert has relevant expertise. 2, if he's aware of his primary duty to the court, if he gives expert evidence and is willing and able, despite the interest or connection with the litigation or a party, to carry out that duty. And if that expert has an interest which is not sufficient to preclude him from giving evidence, the interest may nevertheless affect the weight of his evidence. And on another, which is what I think Franklin also talked about, or also in the practice directions where Ibrahim was asking you about when the expert has been called by one of the sides and he tends to lean on one side. From this case, these principles that were laid down, the expert should be aware of his primary duty to the court to give expert evidence. And then on another case of Wainaina versus Republic, this was on handwriting expert. It was held that while a handwriting expert may in a proper case say he doesn't believe that a particular rating is by a particular person, the most he should ever say on the positive side is that 2 ratings were similar so as to be indistinguishable, and he might comment on unusual features which may make the similarity more remarkable, which when you compare with the practice directions you say, one of the practice directions was he should specify on any limitation of what he's giving as expert evidence.
Yes,
or any
exactly.
technique used or any method used.
Very good, Chelsea. You see now, you see what we, from the moment I asked the question, can you see how we have progressed? Now we are now, and we've picked out what the relevant law is. The same, it's that step of doing any legal research. Relevant facts, relevant law, apply the facts to the law, you do the synopsis, you give any qualifications, and then you conclude. Or limitations to whatever you're researching, then you move. So this is basically, it's the same, nothing has changed. So just building up, we've had the question, which is pretty much a compare and contrast question. We've tried to understand what the Kenyan position is. We pick out the law, we pick out the legislation, we pick out the cases, we discuss them. And then now what the two Chelseas have done is now apply the law to the facts and compare and contrast, which we are continuing as well with Ronald. Go ahead, Ronald. And then Arike, go ahead. Ronald first.
Thank you, sir. I wanted to mention that we mentioned earlier about admissibility test of evidence. And we said that admissibility is basically the credibility. And I thought also to add that it also talks about compliance of the procedure or the process through which an evidence goes through before it can be admitted in court. And in that, in connection with that, I thought about the Constitution, and I was looking at some articles in the Constitution that actually gives the statutes and the subsidiary legislations that he just mentioned. And among them is like Article 47, which talks about fair administrative action. Article 48, access to justice. Article 50, fair hearing, among many others. I thought to add on that point.
That's also good. You bring now the constitutionality question, or you bring the constitutional linchpin, which is obviously the overarching law, and expert opinion evidence, and ensuring that it is safe and not misused, and it is not there's some structure to it, can be traced back to the Constitution and this, the articles on fair trial, access to justice, and so on and so forth. Yes, that's I agree with that. Arike?
Okay, so this is particularly as it relates to civil procedure. Under the civil procedure rules, or the 11 rule 7, G, or the 11 rule 7 G. So at least 30 days before the hearing of the suit, a trial conference shall be convened by the court for the following purposes: making appropriate orders relating to expert reports, including the exchange and admissibility at trial. So it seems for us, part of our procedure is that we will make, the court will make the orders relating to expert reports and the exchange during the trial conference, 30 days before at least 30 days before the hearing of the suit.
So the expert report must be, say that again, please, just repeat it for everyone. Hello?
I was saying, so as Order 11, Rule 7, 1G, at least 30 days before the hearing of the suit, a trial conference shall be convened by the court for the following purposes: appropriate orders relating to expert reports, including their exchange and admissibility at the trial. So I think that is part of our procedure as it relates to expert witnesses.
Agreed. And now that has to be, those 30 days and those appropriate orders now have to be linked with all the case law that Fatma and the two Chelseas were mentioning. So those cases will now be used to guide the magistrate or the judge as to what would be appropriate orders. What is the level of what is the scope of expert witnesses? How should it be presented? Who should do it? What are the rules? What are the criteria that needs to be fulfilled, and so on and so forth? So all these are linked. Is there anything in the Criminal Procedure Code that talks about expert witnesses? Because I would imagine that expert witnesses would be more relevant in criminal matters. Not more relevant, but would feature highly in criminal matters even more than civil matters.
Well, I've not been able to check the Criminal Procedure Code because I don't have a physical copy, and Kenya law at the moment is not showing the acts for some reason. But if I'm able to access it, I will search for it and put it in the chat.
Okay, no problem. So are we together? Are we seeing how we are building an answer, or rather a response to that kind of question? I don't like using the word answer because answer seems to imply that there's a right or wrong answer, and I'm not really too keen on that. I'd rather, as lawyers, because we are lawyers, I'd rather say that whatever you say, you have to back it up with the law or a case or a legal opinion of a legal scholar or so on, a legal article. You just have to back it up, because our job as lawyers is to be persuasive, but also to base our arguments on sound legal principles and legislation and so on and so forth. So, and authorities as well, legal authorities, which would be case law. So we have to make sure that whatever we are arguing is backed by legal authorities and sound legal principles. If there's no backing in that form that I've just mentioned, then whatever you're saying falls flat and just becomes hot air and really cannot be relied upon, and you will not be able to convince a judge, a magistrate, or anyone for that matter that what you're saying has any merit. You see what I mean, ladies and gentlemen? So we need to have that kind of mentality of first of all, we have to understand the legal principles in order to be able to apply them effectively and convincingly and persuasively. because that the same law is the one that one side will say is A and the other side will say is B, but how you persuade them and how you argue that legal argument is what matters, and how you back it up. I just want you to have that in mind, or keep that in mind as we go through this course, this unit. Are there any questions up until there? Any questions? Okay, silence means there's no questions. I want to close on this point because the creme de la creme, the highlight of this topic obviously would be the Fry case and the Dober case. And I don't want us to rush through it. So I'd like to propose that we start with that next week. That will be the North American experience. Who is presenting on the Fry case and the Dober case? I believe there are 4 people, 2 on the Dober and 2 on the Fry. I'm presenting on the Dober classes. Okay, who are you presenting with? Arike? Not Arike. Who was speaking? Sorry. Fatma.
Yeah, Nuru is going to talk about the rule that comes, and then I explain the case.
Okay, so you are Nuru, okay? Okay, and then on the Fry case?
On the Fry case, it's I, Ronald, and Chelsea Wanjiru.
Okay. So we'll start with you for next week. So let's start on time at 2:30, and then we can hopefully spend an hour on that, so we can interrogate that. We fit those 2 cases, compare and contrast them, try to understand what the issues were when it comes to admissibility, because I believe that those cases are also mentioned in our in our authorities, in our case laws, or the principles therein are actually used in our case law. So we need to understand where they come from, so we know how to apply them appropriately when it comes to admissibility of evidence, of expert evidence in court. And then once we finish that, then we can move on to our next topic, which is agency regulation of science and technology. And then we'll probably finish it. We'll take the next hour and a half to finish that. So we're planning to spend about 2.5 hours on finishing up the Fry and Dober cases, and then going through the agency regulation of science and technology. Ibrahim, you have a question? Thank you, Arike. Just a second, Ibrahim, before you start, I'm seeing Arike has posted that the criminal procedure only provides for fees for expert opinion. And what I'm trying to hint at when I was asking this question is for us to be able to see the loopholes, the gaps that we have in Kenyan law as far as it comes to expert opinion, and be able to discuss what a solution to that would be. Like, what do we need to do to make sure our expert opinion evidence is tip-top and is not is well structured. Also, just because other jurisdictions have gone to a lot of detail doesn't mean that we have to copy-paste the way we sometimes are prone to do. Maybe in our specific situation, in our idiosyncrasy as a Kenyan jurisdiction, we might not even be able to fully implement what is being done in other jurisdictions because of the way our structure is created, because of our particular, legal culture, jurisdictional culture, etc., etc. So we also need to be very aware of that and be able to pick what works for us and what doesn't. So it's not to say that just because maybe there's a wisdom to us not being so super structured as the Australian situation is. Maybe there's a reason to that, and maybe we should just stay the way we are and leave our judges freedom and room to operate in the system in the way that they have been operating under the current laws. So that could also be an argument, but you also need to back that up. It's not just to say that, oh, we should just, stay the way we are and keep quiet. No, we have to be able to argue for both sides. And that's what we're trying to do. So I'd like us to keep that in mind, because that could very well be your exam question. And already I'm devising a more detailed question to put you all on your toes for the exam. So don't count that question out. I'm just letting you know. Yes, Ibrahim, you were saying something?
Yeah, Malim, mine is not a question, it's just a request. I agree with a lot of materials that really helped us a lot, but I realize the PowerPoint you are using also has, it has some good points that will help us to enriching our understanding. So if it may please you kindly, will you mind to share with us also the PowerPoints?
Okay, I have something to say about that. In fact, I'm surprised your class has waited this long to ask that question. Usually it's the first question in the first class. So I guess that's commendable as a group. What I don't like with giving my slides out, especially at this early stage, is that it becomes a substitute for research. And I don't want to encourage that, especially in the beginning. So that's why I'd rather give the materials and leave you to do your own research. You come, we discuss, and all I'm doing with the slides is just pointing out certain bits and pieces. What I'm wary of doing is giving slides this early, and then everyone uses that as their research point, or rather as their study, and they don't bother to go outside of what I produce or what I provide as slides. So I take your point, Ibrahim. I will see when will be an appropriate time to share that, but it probably won't be during this period when we are going through the syllabus. I'll probably give it just before the exams as an aid memoir, and not as I want us to make sure that throughout this few weeks that we are together, everyone is actually doing the research, so that whatever when I do release these slides, they're not a substitute for studying. They're just something to help you memorize, or rather help you remember, what you've been researching throughout. But we'll keep talking about that. Yes, Ngaina?
Yes, Mwalimu, you had given us a brief overview of how next week's class will pan out. I want to remind you that there was a case actually that you gave me together with Mbaru.
Which it was?
USA versus Stockpisel or something.
Thank you. That will be that. Yeah, that is included in next week. Yes. So that whole hour will include Fry and Doba and USA versus Stazepchikel, whatever that, I can't pronounce it. And I've been watching that case for years. But you'll just have to bear with me. Yes, you'll be part of that. Don't worry, I will not leave you out, Ngaina.
Okay, sir.
All right. Any? I see Chelsea Owino. Yes, go ahead.
Yes, sir. I think my internet is a bit faulty, but I had a question. I had you mentioning something about a possible, exam question that we shouldn't rule out something, but I didn't hear it quite clearly because you were breaking on my end. So maybe if you could repeat it, if it's not too much trouble.
I was just saying that I want us to keep in mind that we should be able to back up whatever we are saying with the law, so that we don't just make empty arguments without backing anything up. And a question like what we have discussed today, I just wanted to throw that out there and put you in perspective, so you know what you are preparing yourselves for, so that you're able to think in those terms when it comes to answering any legal question for that matter, because that's how you're going to be approaching things in practice. So you might as well start now. And think of things in a practical way, and try not to think of things in a very abstract way when it comes to answering legal questions or CATs, etc. So I just wanted to make sure that you are aware that you have to. It's imperative that you back any argument that you make, any submission that you make with legal authorities, with statute, with subsidiary legislation, with legal articles or journal articles where it is relevant, and so on and so forth, so that you get a well-reasoned argument that is difficult even to challenge. But when you don't say something, and that's why I was trying to steer the conversation away from, in as much as it is, I'm not saying it is irrelevant, but for the purposes of our class, we should try and steer clear of discussions about what happens in practice, not in practice, what happens when people get bribed and courts get compromised and this, that, and the other, because that's not going to help us for the purposes of our learning. So that we can discuss in at lunchtime or in the bar or when we're going to gym. But as far as our discussion is concerned, it doesn't really help us move the discussion forward. And that's the only reason why I was steering the conversation away from that. So yeah, I think I've even added more things than I said last. Thank you, Chelsea. Yes, Ronald?
Thank you, sir. This is maybe different, but it's just a concern. I'm sure you are aware. I don't know if it's only about me, but I'm trying to guess that you are aware that as we go on with our classes, there are chances of drifting maybe more into science, or sometimes more into the law of evidence. And I would like you maybe to comment on that and give guidance.
What is the concern?
Because so far, personally, this is personal. So far, there is a feeling of the law, science, and technology being more of the law of evidence. And sometimes most of the articles you've shared with us are also more of science. And I feel that I need guidance, or basically your comments on that, and maybe can help us stay on the track and
I say what you want to say. You are dancing around in circles. You're not actually hitting the nail on the head, because I'm trying to understand what the concern is. Is the concern that that you think the articles, the scientific articles I'm giving you are too sciencey, or is it that you want more law? Don't. I'm telling you, it's a safe space. As long as you say it with respect and you don't insult me, I will answer your question. So say what it is you want to say.
Okay, maybe if you can just offer guidance against confusion.
What is the confusion? Again, you're not hitting the nail on the head. I'm not understanding. What's the confusion? If you tell me where the confusion lies, I'll be able to address it appropriately.
I really don't have an appropriate way to put it. I can see Mohammed is maybe can help me drive my point.
Mwalimu,
go ahead, Ibrahim.
I think if I of what Ronald is saying, probably LST could be an extension of evidence law. It's like evidence law 1, which we had it, and this is evidence law 2. Yeah, something like that.
Okay. Okay. Again, I think, Ibrahim, maybe you've fine-tuned it a little bit, but I'm still in the dark, so I'll just answer. Yeah.
When you read the cases and even the application, everything, you feel like we are in an evidence law class, honestly. That's
okay.
Yes.
Okay. If I'm hearing what I'm hearing, then there's nothing to be concerned about, because law is pervasive. Just because you studied criminal law or a law of evidence doesn't mean it ends there. Everything you're studying, especially the core units, will appear in some way, shape, or form in some other unit that you do, or some elective or something else. That should not concern you, that you feel like you're doing a law of evidence. We're in LST, this topic in particular within the LST course, we're correlating the law of evidence as it pertains to expert testimony and how expert testimony and admissibility rules are applied in the courtroom. That's all. There's nothing for you to be concerned about. And in fact, you should be happy that you are remembering your law of evidence and actually applying it in a more specific way, as opposed to just the general evidence, law of evidence principles. It would be weird if we're doing law, science, and technology and talking about science in the courtroom, and then I leave the law of evidence out. You'd be asking me, I'm surprised you're not talking about law of evidence. That would be the question. So if your question is that it's reminding you of law of evidence, then well done. I think you're listening in my class, and yes, it should remind you of law of evidence because it's very relevant in this. Have I answered your question, Ronald?
Yes, sir, clear.
Okay. Are you happy now? Are you less conflicted and concerned?
I believe so.
Well, I hope so anyway. And as long as you are less concerned than you are before, the remainder you can pray to God and He'll remove those concerns. but you should not be worried that law of evidence is cropping up. Property law crops up in all sorts of units. What else is there? Contract law crops up everywhere in law. So it would be weird if you did, let's say, what do you call it, conveyancing law, and contract law doesn't come up. Or if you're doing international trade and contract law doesn't come up. It's just how it goes. Okay. Any other questions or concerns or comments? Okay. I take it everyone is happy, with the slight exception of Ronald, but I'm sure Ronald, by the time he sleeps and wakes up tomorrow morning, he'll be happy. I am counting on it. So thank you very much for your attention and your contributions. I think every week we speak, it gets better, and that's how I'd like it to be, that we're all, interrogating all these issues, and even the fact that you are figuring out that law of evidence is cropping up, for me, is a plus, because it means then we're all paying attention, we're all understanding the concepts and applying them properly. So do not be worried about that. You should be worried if I was not bringing it up. Law of evidence, that is. So next week, as I said, we'll be focusing on those 3 cases, and also Rule 702 as well, which was the intermediary between the Fry case and the Dober case, and then the USA versus Starr case, which came after the Dober case, which will show how the Dober principles were being applied afterwards, after that decision. So let us meet next week at 2:30 sharp. Please let everyone know. Whoever was supposed to do Hillstead versus R, you have your chance next week to let me know and to present. If you don't, I will know who you are at the end of the day, and I will deal with you accordingly. So let whoever it is know that. Right, so have a good evening and good weekend, and we'll see each other next week, same time.
Thank you, sir.
Thank you.
Thank you. Thank you.